live.
Hello and welcome to the Federal Society's Seat at the Sitting program for November. I'm Nate Kazmarek, Vice President for Practice Groups and Networks. Before we dive in, I wanted to mention how excited we are for our National Lawyers Convention, which is set for 1 week from today. This year's theme for the convention is New Legal Frontiers, and our team is putting the finishing touches on this wonderful event. The event is sold out, and we look forward to welcoming so many of our members in person next week. If you don't have a ticket, this is a reminder that you can watch every panel via the live stream. I encourage you to take a look at the convention schedule and plan to catch the panels and speeches that most interest you. Today, we've assembled a great panel of legal experts to navigate the oral arguments at the court for next month. This panel will cover the cases and then take audience Q&A in 90 minutes or less. As you know, the Federal Society doesn't take positions, and all views expressed in this session belong to our speakers. And it's my pleasure today to welcome our moderator, Logan Spina from ADF. Logan, how are you today?
I'm doing great. How are you, Nate?
Very, very well, and delighted to have you with us. We're excited to have you guide this conversation today and appreciate all of your help. Logan serves as legal counsel for the Center for Free Speech at Alliance Defending Freedom. Before joining ADF, he served as Deputy Policy Director in the Missouri Governor's Office. Logan is a graduate of the University of Virginia School of Law, and his BA is from Patrick Henry College. For full bios for Logan and all of our presenters today, you can find them in the Zoom Resources tab if you've joined us via Zoom, or on our website, fedsoc.org. Towards the end of the webinar, we'll open it up to audience questions. So think about what you'd like to ask our experts as you listen to the discussion. For those of you joining us via Zoom, questions can be submitted with the Q&A function at the bottom of your screen. With that, Logan, thanks again for joining us. The floor is yours.
Thank you, Nate, and good afternoon to all of you. Thank you for joining us. I am delighted to be able to moderate this discussion here today with 4 excellent panelists. I'm going to give a very brief introduction to each one that will only scratch the surface of their qualifications, and then we'll move through the cases to be heard in November. As we go, as Nate mentioned, we will be taking questions at the end, but you're welcome to submit them just whenever you think of them. As he also mentioned, there is a specific Q&A function at the bottom of your screen beyond just the chat function. We'd ask that you put your questions in there. That will make it easier for me to find them and then relay them to our panelists. Though I will try to keep my eye on the chat as well, just in case anybody gets too excited and forgets to submit it through the Q&A function. So our panelists were joined today by Professor Jacob Schuman. Professor Schuman earned his JD at Harvard Law School, after which he clerked for the U.S. District Court for District Judge Boasberg in D.C. and the U.S. Court of Appeals for the Fourth Circuit with Judge Boudin. Before joining academia, Professor Schuman served in the appellate unit of the Federal Community Defender Office in Philadelphia, and he also did some white-collar defense work. He's now an associate professor of law at Temple University Beasley School of Law. We also have Mr. Zach Morgan, a graduate of George Mason University School of Law. Mr. Morgan spent many years litigating First Amendment cases with the Institute for Free Speech. He also served as counsel to Commissioner Dickerson of the Federal Election Commission. He's currently senior litigation counsel at the Washington Legal Foundation, focusing on appellate litigation. We also have Professor Thomas Berg, who earned his law degree from the University of Chicago, after which he clerked for Judge Rubin on the Fifth Circuit Court of Appeals. Before joining academia, he practiced law in Chicago and is presently a professor of law and public policy at the University of St. Thomas School of Law, where he teaches on intellectual property and constitutional law while overseeing the Religious Liberty Appellate Clinic. And finally, we're also joined by Professor Erica Zunkel, who earned her JD from Cal Berkeley School of Law, after which she clerked for Judge Vasquez on the U.S. District Court for the District of New Mexico. Professor Zunkel then worked as a federal public defender in San Diego and has carried her experience into her academic career, as she's now a professor at the University of Chicago Law School, where she directs the Criminal and Juvenile Justice Clinic. We're very grateful to all 4 of these panelists for giving us their time and lending us some of their expertise and insight today. I'm very excited to hear what they have to say about all these cases. So we'll just dive right in. The first case we're going to cover is Rico versus United States, to be heard on November 3rd. And I think Professor Schuman will describe this case for us.
Thanks so much, Logan. It's great to be here with everybody. First, just a quick disclaimer. I filed an amicus brief in this case on behalf of the National Association of Federal Defenders in support of the petitioner. I also personally contributed to the circuit split here by litigating and losing the issue in this case before the Third Circuit back when I was a public defender. But I'm going to work hard not to turn this into a therapy session for myself. I'm going to just give you an objective overview of the issues in the case. Okay, so the question presented in Rico v. US is whether the fugitive-tolling doctrine applies in the context of supervised release. And to explain to you what that means, I need to tell you a little bit about supervised release. Supervised release is a form of community supervision in the federal criminal justice system. It's a term of conditional liberty in the community imposed as part of the punishment for a crime that includes supervision and reporting by a probation officer with violations punishable by imprisonment. So if a defendant is convicted of a federal crime, the judge can sentence them to a term of imprisonment, say 10 years, and then can follow that term of imprisonment with a term of supervised release, like a 3-year term of supervised release. That term of supervised release will consist of a set of conditions like not committing another crime, attending regular meetings with a probation officer, taking drug tests. And if the defendant violates any of those conditions, the judge can revoke their supervised release and send them back to prison. Supervised release is a really big deal. About 75% of all federal criminal defendants are sentenced to a term of supervised release, and the rate is even higher if you exclude immigration defendants or defendants sentenced to less than a year in prison. In total, there's about 110,000 people currently serving terms of federal supervised release, which is only a little bit less than the total number in federal prisons. Congress created supervised release in the Sentencing Reform Act of 1984 to replace an older form of community supervision called parole. Parole dates back to the early 20th century. And the way it worked is that if a defendant was convicted of a crime, they'd be sentenced to a term of imprisonment. But after they served 1/3 of that term, they'd become eligible to get early release. If they were granted early release, then they'd serve the rest of the sentence under supervision in the community, subject to supervision and reporting by a parole officer, and with violations of any conditions of parole punishable by imprisonment. So, for example, a defendant might be sentenced to a 10-year prison term, but then after they served 3 years, they'd be eligible for early release, they'd get conditional liberty, and they'd serve the remainder of the 7 years under supervision in the community. If they violated a condition, they could be sent back to jail to serve the remainder of their 7-year term. The reason that Congress abolished parole and replaced it with supervised release is that it thought that parole made the length of the defendant's sentence too uncertain. When a judge sentenced the defendant to prison, nobody knew how long they'd actually end up serving because it would depend on whether or not they'd be granted parole. So by abolishing parole and replacing it with supervised release, Congress tried to make prison sentences more predictable. You would know when someone was sentenced exactly how long they'd spend in prison, and then exactly how long they'd spend on supervised release. So the question in Rico v. United States is whether the fugitive-tolling doctrine applies to supervised release. Fugitive-tolling is the idea that a defendant should not receive credit toward a sentence during time that they're a fugitive from that sentence. So imagine you're sentenced to a 10-year prison sentence. If you escape from prison, you can't pop up 10 years later and say, oh, I'm all done my sentence. The 10 years you spent outside the prison don't count towards your prison sentence. If we catch you, we're going to put you back in prison so you serve the full term. The question in Rico is whether this same rule should apply to people who become fugitives from supervised release. So the facts are that the petitioner, Ms. Rico, was sentenced to a term of supervised release that was scheduled to end in 2021. In 2018, however, she left her house and stopped reporting to her probation officer. Her probation officer filed a petition with the court alleging that she'd violated the conditions of her supervised release by failing to report to him. And she was finally caught and arrested in 2023, at which point the government sought to revoke her supervised release. In addition to the violation she committed by absconding from supervised release, the government also wanted to hold her responsible for an additional violation, drug possession, that she'd committed in 2022. But she argued that her term of supervised release had expired in 2021, and so she couldn't be punished for a violation that she'd allegedly committed in 2022. In response, the government said that since she'd absconded from supervision in 2018, her term of supervision had been tolled, and therefore it was still in effect when she committed the violation in 2022. So if fugitive tolling applies in the context of supervised release, then Ms. Rico can be punished for this 2022 supervised release violation. But if it doesn't, then she can't be. Ultimately, the district court and the Ninth Circuit both ruled against Ms. Rico and said fugitive tolling did apply to supervised release. But because there's a circuit split on this issue, the Supreme Court granted cert. So that's the question presented. What are the arguments? The petitioner, Ms. Rico's argument is very simple. There is nothing in the text of any of the statutes that govern supervised release that says anything about a fugitive tolling doctrine. And that omission is significant because the old parole statutes, which were repealed by the Sentencing Reform Act, included two tolling provisions. The first tolling provision provided that parole would be tolled whenever the defendant was incarcerated in connection with a new crime. You might call that incarceration tolling. And then the second provision provided for tolling of parole whenever the defendant absconded from supervision. So that was fugitive tolling. However, when Congress enacted the Sentencing Reform Act and created supervised release, it only included one tolling provision for when the defendant was incarcerated in connection with a new crime. So the petitioner here argues that by reenacting the provision for incarceration tolling, but omitting the provision for fugitive tolling, Congress clearly expressed its intent not to authorize fugitive tolling of supervised release. And to the extent that the Sentencing Reform Act might be considered unclear about whether it includes a fugitive tolling doctrine, the rule of lenity would counsel in favor of resolving that ambiguity for the defendant. The government makes a few arguments in response, three of which I think are most important. First, the government says that the text of the Sentencing Reform Act actually does support fugitive tolling because it requires that a defendant sentenced to supervised release be supervised by a probation officer. And the government says that this implies that if a defendant absconds from supervision, they shouldn't receive credit toward their sentence. Second, the government says that even though the Sentencing Reform Act doesn't include a provision for fugitive tolling of supervised release, there was a common law tradition of tolling a sentence whenever a defendant absconded, and that the supervised release scheme should be read to incorporate that principle. The government points to several cases from the parole system that it says recognized a common law fugitive tolling doctrine, in particular, two Supreme Court decisions from the 1920s and 30s, holding that a parolee who wasn't being supervised was equivalent to an escapee from prison, and that their sentence should be considered interrupted and suspended during that period. The government says that there's no reason to interpret Congress's silence on fugitive tolling of supervised release to suggest that it was rejecting this ancient principle. Finally, the government argues that rejecting fugitive tolling would just be a really bad idea because it would violate the deeply rooted principle that criminals shouldn't benefit from their own wrongdoing and shouldn't receive a windfall by absconding from supervision. The government points out that without a fugitive tolling doctrine, a supervisee might abscond from supervision, remain incommunicado until the term expired, and then resurface, all the while avoiding liability for any violations they'd committed. The petitioner offers a few responses to these arguments. First, she says that the Sentencing Reform Act's statement that supervisees should be supervised by a probation officer doesn't imply support for a fugitive tolling doctrine. It just identifies the person responsible for the supervision. Second, she says that there is no common law tradition of fugitive tolling of parole. The cases that the government cites for this proposition actually don't stand for it or are just dicta. And in particular, the two Supreme Court cases they cite both dealt with parolees who'd been arrested in connection with new crimes. And so those cases actually reflect a principle of incarceration tolling, not fugitive tolling. And the petitioner also points out if there was a common law tradition of fugitive tolling, then there would have been no need for the old parole statute to provide for it. Finally, she argues that the government's warning about giving a windfall to supervisees who abscond is misplaced. That's just a policy argument, and it's not appropriate for the court, whose job it is to just apply the plain text of the Sentencing Reform Act. Moreover, she says that the policy concerns that the government's raised are already addressed by a specific provision of the supervised release statute that Congress enacted in 1994 to deal with exactly this kind of situation. It's codified at 18 USC 3583I, and it says that a judge can revoke a defendant's supervised release after their term has expired, so long as a probation officer has filed a petition during the term alleging that the supervisee committed a violation. So if a supervisee absconds and hides out, so long as their probation officer just files a violation petition alleging that they've become a fugitive, once they resurface, then the judge can punish them for that violation, even if their term has expired. So those are the arguments in Rico v. US, and I'm happy to answer your questions.
Thanks very much, Professor Schuman. We're going to move on to the Hain Celestial Group versus Palmquist, which will be covered by Mr. Morgan.
Hi. So Hain Celestial versus Palmquist is, as it often is in these kinds of circumstances, a very, very tragic case, incredibly interesting legal question. So Hain Celestial is a baby food manufacturer, and they sell their baby food products through the general channels of commerce in the United States, including through Whole Foods. The Palmquists, who are on the other side of the V, have a small child. And the small child exhibited really, really, really severe autism. And they pled that they had fed their child exclusively Hain's baby products and that it gave him heavy metal poisoning, and as a result, his autism. They filed a case against both Whole Foods and Hain Celestial in state court in Texas. And again, disclaimer, we had a brief in this case in support of Hain Celestial. So, but again, as Professor Schuman did, I am going to be as even-handed as I can be on this. I at least didn't contribute to a circuit split, didn't do that personally. So they filed the case, and Hain Celestial sought to remove it to federal court. This is one of a series of cases that the court granted cert on this term about removal. There's Enbridge Energy, which is being argued next month. There's the Chevron case on federal officer removal. It's being argued, I think, next month. This has been sort of at the end of this term that we're going to really understand how federal removal works. So the case gets removed to federal court. The court says, Whole Foods was fraudulently joined. The express warranty claim that the Palmquist brought against Whole Foods isn't really a stated claim under Texas law, dismissed Whole Foods from the case, and the case went to trial. And at the end of the trial, the judge granted Hain's 50A motion. There had been no demonstrated causation, and that was the end of the product liability case. Judgment without the verdict. Didn't go to the jury. And then the family appealed to the Fifth Circuit. Now, the Fifth Circuit didn't rule in the merits. What they did instead was they noted that the Palmquists had amended their complaint. And they had, instead of just having an express warranty claim, there was an implied warranty claim. And the Fifth Circuit determined that, that actually means that Whole Foods should have kept in the case. That implied warranty claim brings in the Texas Corporation, Strawbridge versus Curtis, diversity has been destroyed, and remanded the entire case back to state court for a complete do-over. So the question the court ended up taking cert on is, well, what do you do in these circumstances? The case has been tried to a verdict. And is it just, do we have to send it back to state court because the jurisdiction of the federal courts is that finite? Or, and there's this case, Caterpillar versus Lewis from 1996 that Hain Celestial heavily relies on, have considerations of finality and judicial efficiency and economy so swallowed the case that we should just let it go. The case has been tried to verdict, justice has in fact been done, and it doesn't need to go back to state court. So this is a very interesting question of federalism, of the removal powers of the courts. Caterpillar versus Lewis is not a particularly textualist opinion. It's a very prudential opinion. Is the court going to claw back Caterpillar, or is Caterpillar going to expand its scope to apply to these types of cases as well? In our brief, we supported Hain Celestial and noted that there were a couple of additional finality interests that basically if there is a circumstance where it's a close question, you should consider the fact that sending it back to state court means that there's a likelihood there may be discrimination against an out-of-state defendant, which is part and parcel why we have the federal courts dealing with interstate commercial questions in the first place. And then that also remanding back to state court, particularly in Texas, but just generally, also means that it increases the likelihood that the case is going to be decided by an elected official. And if we're going to be considering prudential factors of judicial economy and finality, that those ought to be included as well. So that's Hain Celestial versus Palmquist, and I'm happy to take any questions.
Thanks very much, Zach. And we're actually going to stick with you for another case I think everyone is eagerly awaiting the oral argument on November 5th, which is Learning Resources Incorporated versus Trump.
Yeah, I'm going to take a little bit more time on this one. So the president of the United States is Donald Trump. Donald Trump is a self-described tariff man. His most consistent publicly held political position is that we need to restructure America's trading relationships with the world. And so since being sworn into his second term, he has, through executive order, picked a trade war. And with apologies to the late, great Norm Macdonald, he has chosen as his adversary the world. The president has imposed a 10% general floor tariff on all foreign goods coming into the United States. He's imposed a series of reciprocal tariffs to adjust the balance of trade that the United States has with other countries. And he has imposed specific tariffs on all of the countries' major trading partners, Canada, Mexico, Japan, China. And those rates have gyrated up and down, essentially with the president's whim and in response to negotiations with foreign countries. The Chinese tariffs in particular have gone from about 20% to 145% and up and down. Apparently the president had a call with the chairman of the CCP the other night. That was a very good call, so he's going to reduce the tariffs some more. And how is he doing this, right? Because Article 1, Section 8 entrusts the tariff of power to the Congress, but the president is just doing this through executive order. Well, the president has an answer. He's citing a provision called the International Emergency Economic Powers Act. And IEEPA is our general economic sanctions statute. Basically, the way IEEPA works is the president declares an emergency, and that unlocks the suite of IEEPA powers. The president claims that IEEPA allows him to impose tariffs. And the case is going to be argued on November 5th, and it's just going to be a basic knife fight about statutory interpretation. This entire case is going to be about what the word regulate means in context. So IEEPA has the 76-word provision. It's 50 USC 1702 Alpha 1 Bravo. In those 76 words, there are two words, regulate and importation. They're not next to each other, but they're separated by 16 additional words that speak of compellence and voidance and really what you would expect to find in a sanctioning authority, the kind of things that we allow for asset freezes and embargoes and quotas and things of that nature. The president slams those two words together and says it's regulate importation. The president's brief says that that's a plain, clear delegation of the tariff power to the president. He thinks this as a basic matter of the English language, that's what regulate importation means. Now, the president does have some legal authority for this. It's not merely just assertion of how the English language works. In 1971, there was the so-called Nixon shock. And as the president took the country off the gold standard, he also, through executive order, imposed a series of very time-delimited tariffs in order to deal with the effects of the dramatic restructuring of the global economy. And in 1975, the Federal Circuit's predecessor court, the Court of Customs and Patent Appeals, determined that that executive order had to be cited in the IEEPA's predecessor, the Trading with the Enemy Act of 1917 as amended, which included some similar language and said that it upheld those tariffs. Now, it upheld those tariffs because they were time delimited and not particularly broad. And the tariff challengers have spun Yoshida back on the president, because the Yoshida case also says that an emergency-based global license to tariff would, quote, sound the death knell of the Constitution, end quote. So it's not the best case the president has. It's not perhaps the best case the president would want, but it is the best case that he has outside of just the basic statutory argument. The president has also contended that, yes, IEPA does allow him to set rates, double, treble, suspend, eliminate them, but they're limited. The National Emergencies Act requires him to impose the emergency. Emergencies lapse after 1 year. Of course, the president can renew those emergencies endlessly. We are currently living still under the emergency that was declared by President Carter pursuant to the National Emergencies Act in relation to the seizure of the American embassy in Tehran, for instance. Just endlessly, those can be renewed. The president has also pointed out that Congress can pass a joint resolution to undo the emergency and thereby deteriorate and undo the tariffs. That's true. The National Emergencies Act was passed in 1976. So back then, that was a legislative veto. That after INS versus Chadha in 1983, that falls to the wayside. Now the president would in fact have to acquiesce in the signing of the joint resolution. So the president's limits are all limits that the president would have to agree to, which I think does sort of undo the president's legal theory. And again, WLF had a brief in this case. We do not think the president's legal theory is correct. So perhaps I'm just, drinking my own Kool-Aid here, but that's what I think. Inevitably, what this comes down to is, what does the word regulate mean, right? And I think what this is going to collapse into in practical application is this is going to become a major questions case. That the word regulate, the president may be giving it an uncommon meaning. The challengers note that the power to regulate commerce is not generally considered to be the power to tax. And if regulate has the weight the president has on it, that would mean that Congress had kind of obliquely and cryptically and silently in 1977 delegated the tariff power to the president. No president over the next 50 years has ever picked up IEPA to do tariffs. That can't be right. This is just a major questions case. Regulate then is like waive or modify from the HEROES Act, where the court struck down President Biden's effort to do debt cancellation. Or it's like the word necessary, which President Biden leaned on in order to do the eviction moratorium. Those cases only involved tens or hundreds of billions of dollars, not an effort by the president to control the entire $7 trillion import-export market for himself. That's the gravamen of the challengers' approach. They've also asserted a non-delegation doctrine claim that if it is true that IEPA allows for tariffs because there's no floor and no ceiling, it violates the intelligible principle. My guess, especially, and maybe this is just me being disappointed with last term's decision in FCC versus Consumers Research, that's not where the court's going to go. I don't think they're going to end up making this a non-delegation case. I think this is going to be a major questions case. And I don't really want to hazard any general predictions on how this is going to go. I always, whenever I'm asked to do a prediction about anything, I have this memory of Bill Kristol going on Fox in 2008 saying, next week on Tuesday in Richmond, Barack Obama is going to announce Tim Kaine as his running mate. And that obviously didn't happen. But I'll say two justices to watch. One is Justice Kagan. Kagan dissented in all the major questions cases on the Roberts Court. And she has said, in fact, that the major questions canon itself is kind of a trick. It's a get out of text free card in which you can impose your policy preferences on an otherwise clear text. I'm curious if she's going to say how she's going to approach this case. Is she now going to acquiesce in the major questions precedents and say, well, I dissented, but that's law. If anything was a major question, it has to be this multi-trillion-dollar question. Or is she going to treat it as a more quote unquote normal statutory interpretation case? And the final point I'd like to make on who to watch is Justice Kavanaugh. In Consumers Research, Justice Kavanaugh wrote a concurrence that I guess can best be understood as a request for legal advice from the parties and amici in the tariff case, because he said he did not believe that the major questions canon applies in the context of the president's foreign affairs powers. And tariffs obviously implicate foreign policy. They change how other countries interact with the United States. And it'll be interesting. I'm watching to see how Kavanaugh deals with that. the difference here in as to what he said in Consumers Research, or at least our pitch is what we wrote to him in our amicus brief. So if you're listening, Justice Kavanaugh, you can turn to the relevant pages of the brief. We said that, well, yeah, that may be true, but there's no independent Article 2 authority to tariff. There's no Article 2 authority to tariff at all. That's an Article 1 power. So your concerns about the president having the necessary flexibility in order to conduct foreign affairs isn't implicated. This isn't a sole organ doctrine or commander-in-chief question. This is a straightforward, did Congress delegate a core function of Congress's powers so obliquely and so broadly to the president? And I probably have gone over my time. I apologize, but I'm happy to answer any questions.
Thanks very much, Mr. Morgan. That was all fascinating, a lot of interesting issues. And as you can imagine, we've got some questions for that. So we're definitely gonna be coming back to you. But the next case we're going to cover is Lander versus Louisiana Department of Corrections and Public Safety, and Professor Berg.
Thank you. Great to be here. Let me give the obligatory disclaimer. I filed a brief in this case. On behalf of the petitioner, Damon Lander, so I will try to present the two sides' arguments and also give a little bit of my own sense about the direction of the court. The issue in this case, as the slide says, is whether an individual may sue a government official in his individual capacity for damages for violation of the Religious Land Use and Institutionalized Persons Act of 2000, which we don't want to keep giving the whole title of that, so it's fondly known as ARLUPA. So the facts of this case are that Damon Lander, the petitioner, was nearing the end of a 5-month sentence on a drug charge in the Louisiana state prison system. He was transferred to another prison for the last week, sort of an outgo prison. And Damon Lander is a practicing Rastafarian. He had long hair that he had grown for a long number of years, almost down to his knees. When he arrived at the new prison, he explained that this was a religious practice, and he actually provided a copy of a federal court opinion saying that this statute, ARLUPA, protected his right as an institutionalized person to engage in this religious practice in the prison, that he could wear dreadlocks. Despite him providing a copy of this ruling, the warden of the new prison ordered the guards to restrain him in a chair where they forcibly cut his dreadlocks. He was then in that, and shaved his head. He was then in that prison for a short time and was released. He sued in federal court for this violation of his right to religious exercise, suing both the department and the state officials. Now, ARLUPA was enacted in 2000 by Congress, and it provides that institutionalized persons, primarily prisoners in state or local institutions, can sue, bring a claim or defense if their religious exercise has been substantially burdened and the state does not have a compelling interest but in that burden, right? So strict scrutiny applies under ARLUPA. The Fifth Circuit threw out his claims against the individual prison officials for damages, holding that ARLUPA does not authorize a damage suit against individual officials in their individual capacity. Of course, Lander did not have a claim for injunctive relief. His sentence was over. His injunctive claims were moot. He did not have a damages claim against the state because of sovereign immunity. So his remedy, and a remedy in a situation like this, would be damages against the prison officials in their individual capacity. The Fifth Circuit, however, following its some earlier precedent, adhered to that earlier precedent en banc and said that ARLUPA does not authorize an individual capacity damages suit against prison officials. Okay, so 5 years ago, the Supreme Court decided in a case called Tanzan that under a related statute, the Religious Freedom Restoration Act, private plaintiffs could bring damages suits against federal officials. RFRA, the Religious Freedom Restoration Act, applies to federal officials. In that case, it was FBI agents who had placed a Muslim persons on a no-fly list because they allegedly had refused to cooperate in helping with surveillance of mosques and other people in their religious community. So the Religious Freedom Restoration Act, like ARLUPA, says that whenever government actions substantially burden religious exercise, the government has to justify them under strict scrutiny. So in Tanzan, the court held unanimously under RFRA that statute authorized individual capacity money damages suits. The term in the statute is appropriate relief, and the court held that individual capacity damages suits were appropriate relief in the light of RFRA's background and context, because RFRA, it in turn used key language from Section 1983, the classic civil rights statute that does authorize damage suits against state and local officials, and because of the purposes of RFRA, that there are key cases where damages are the only effective means of preserving or protecting a person's religious exercise, including some claims by federal prisoners. For example, if the prisoner has been transferred from one prison to another, injunctive relief may be moot. Prisons have been known to transfer inmates for the purpose of mooting damages claims. It's happened. And other situations, for example, the court in the RFRA case cited a prisoner whose religious scriptures, their books, whether it's Quran or Bible or whatever, were taken and destroyed. That's not really a matter of injunctive relief as the remedy for that. The more appropriate relief would be damages for that destruction of your religious property. So that the Supreme Court held that unanimously in Tanzan in 2020. Landor argues that the same rule should apply to ARLUPA, because ARLUPA is a parallel statute. Indeed, the court has called it a sister statute to RFRA. RFRA was enacted in 1993 to effectively reverse the Supreme Court's decision in Employment Division versus Smith. When RFRA was enacted, it applied to both federal and state laws. The Supreme Court then, in a case called Birney in 1997, struck down the application of RFRA to state and local laws, leaving only its federal applications. That's why RFRA was the statute that applied to the FBI agents. But with no state and local applications, Congress intervened and enacted ARLUPA in 2000, using its powers to regulate, to put conditions on federal spending and its commerce power. And so it applied the same test as RFRA to land use and prison contexts, and in using the spending power in most cases to apply ARLUPA to prisons. State prison systems that receive federal funds are subject to the rule in ARLUPA. So Landor says the same rule should apply under Arlupa because it uses the identical words. It is, in fact, a reenactment of Arlupa. And its context is completely tied to RFRA, right? In fact, remember again that RFRA originally applied to both federal and state actions, and Arlupa meant to restore that protection for against state and local actions that the Supreme Court had excised in the city of Bernie case. The state and the Fifth Circuit and some other courts of appeals has said, well, Arlupa may have the same text, it may have the same background as RFRA, but there's a big difference. Arlupa was enacted under the spending power, and whereas RFRA rests on probably on some combination of federal powers to take whatever federal statute is involved in the RFRA situation and create protections for religion under that statute, apply protections for religion to that statute. So whatever statute justifies the underlying federal power, whatever power justifies the underlying federal statute, that also justifies applying RFRA to that statute. But in the case of Arlupa, applying it to state and local laws, it is the spending power. And that gives the state, the state then makes two arguments based on that. First of all, the spending power test from various cases like South Dakota versus Dole, Pennhurst, and others makes clear that one requirement is that Congress make its conditions clear in a spending power statute so that the state or entity that is receiving the money can know the consequences, what it's taking, what it's accepting along with the money. And so the state says the fact that RFRA authorizes damages does not mean that Arlupa does. Spending power statutes require clarity. RFRA's context did not require clarity. That's the first argument. So I'll work through that one now and then turn to the second one. These are both, in other words, arguments about the spending power. This is a religious liberty case, but it's also a case most fundamentally about the scope of the spending power. So with respect to this clear statement rule, the Landor replies with basically the story and the background that I've laid out, which is that RFRA and Arlupa are so closely connected that it's clear that if damages are authorized under RFRA, they must also be authorized under Arlupa. Remember again that RFRA applied to originally to both federal and state actions. The state applications were cut off by the Supreme Court, and then Congress reattached them in the terms that Landor uses and our brief also used. Arlupa is not just a related statute to RFRA, it is a clone of RFRA. It's the same genetic material. And so it makes absolutely no sense to treat Arlupa differently on a matter such as appropriate relief, to treat that differently, from RFRA. So the question here will be how far the court goes with its clear statement requirements in the spending power. The state argues at one point that there is a supercharged clear statement rule. They actually use that language. The Landor replies that, the court hasn't adopted that. The court has said you don't have to have magic words in a statute in order to be clear. And Landor says that the combination of the unanimous decision in Tanzan about RFRA together with the close identity between RFRA and Arlupa means that Arlupa is also clear and meets the spending power standard. The second argument that the state makes about the spending power is that the spending power does not authorize Congress to reach non-recipients of the federal funds or entities or persons that have not in some way signed a contract accepting the conditions that go along with the funding. And in this case, it would be the state of Louisiana that signed the contract and is the direct recipient of the funds, and officials are neither the direct recipient of the funds nor signatories to a contract. This pushes a theory of the spending power that may or may not have some purchase on the court now, which is the idea that the spending power should be understood purely in the nature of a contract, that Congress, the federal government provides the money, and then there are conditions that go along with that, but it's just all, it's all about the contract, the agreement between the government and the recipient. Landor argues in response, pointing that this would this provision is that kind of approach has not been adopted by the court. There are at least two cases, for example, on the bribery of officials in government programs receiving federal funds. One is Salinas from 1997, which involved a bribery prosecution of a state prison official for accepting a bribe from a prisoner to give him favored treatment. That's that bribery prosecution, again, under the spending power, reaches a non-recipient of the funds, the official. And even one step further, in the Sabri case in 2004, the court extended liability or upheld liability as applied to the person who gave the bribe, who is not even a state official at all. And in all these cases, the reasoning is that the necessary and proper clause gives Congress the power to ensure that its conditions on funding the bribe giver or the official receiving the bribe. Here, Landor says the burden on religion is imposed by state officers, even if they're not the direct recipients of the funds. They are the ones who are undermining Congress's desire that religion be protected in federally funded institutions. So that's in response to that, the state says those cases were specifically about federal funds and preventing federal funds from being diverted through bribes. Bribery is a unique kind of situation. This doesn't involve that. Landor says, no, the spending power allows Congress to impose various kinds of conditions on funding, and not solely those that have something directly to do with ensuring the integrity of the funds themselves. So I think the bottom line on this case is that it's the question will be between the court has developed a real record of enforcing both RFRA and RLUIPA strongly as part of its commitment to religious liberty. That will run up against this case, against arguments that the spending power needs to be constrained. And I think the question is how much the conservative majority on the court will be looking to reduce the scope of the spending power, and whether that will overcome their also strong commitment to these statutes and the identity between RFRA, where they've already said that damages are authorized, and RLUIPA. Okay, I'll stop there and happy to take questions.
Thank you very much, Professor Berg. That's a very interesting tension between the enforcement of RLUIPA and the spending clause. We're going to move on to Rutherford versus United States, which is to be argued on November 12th, and that's going to be covered by Professor Zunkel.
Thank you, Logan. Thank you very much to the Federalist Society for inviting me to speak today. Rutherford and its companion case, Carter, center on an interesting and impactful issue about a statute that the Supreme Court has never addressed. That is the federal sentence reduction statute. Congress enacted this statute in 1984 as part of the Sentencing Reform Act at the same time that it abolished federal parole. So like others, in the interest of disclosure, my clinic students and I, along with the team from Cravath, Swain, and Moore, authored an amicus brief for Carter and Rutherford at both the cert stage and the merit stage. The views expressed here and in those briefs are my own and not those of my institution. These two cases will ultimately determine under what circumstances federal prisoners can seek sentence reductions, as well as the scope of the U.S. Sentencing Commission's authority to set policy in this area. So, a little bit of a background on this statute. The federal sentence reduction statute, which over the years came to be known as the compassionate release statute, authorizes judges to reduce sentences when extraordinary and compelling reasons exist and other statutory factors are satisfied. Now, Congress expressly delegated to the Sentencing Commission the task of describing what should be considered extraordinary and compelling reasons for sentence reduction, and said that Congress needed to provide the criteria to be applied and a list of examples. The only explicit limitation Congress placed on the Commission's authority is that the rehabilitation of the defendant on its own, alone, shall not be considered an extraordinary and compelling reason. So, for decades, the Federal Bureau of Prisons served as the gatekeeper for sentence reduction motions. Under the statute, as it existed from the time that the Sentencing Reform Act was passed, only the Bureau could file a motion for a sentence reduction. The Bureau of Prisons rarely opened the gate, resulting in frustration among Democrats and Republicans in Congress with the Bureau's antipathy to using the statute. And this led to an important change in President Trump's 2018 bipartisan First Step Act, which for the first time allowed criminal defendants themselves to file motions under the sentence reduction statute. Now, these cases also implicate another key First Step Act change that is front and center in these cases, and that is the Act's landmark changes to criminal sentencing penalties for certain firearms offenses and also certain drug offenses. These cases in particular involve the changes to firearms offenses. So a little bit about those. Over the years, federal prosecutors had frequently filed mandatory minimum firearm counts, where the second and subsequent counts carried consecutive 20 to 25-year terms in a single case. And the result of charging in that way was to ensure extremely long sentences that judges had no power to go under because they were mandatory. Now, this draconian practice known as stacking faced widespread criticism. So, what the First Step Act did was clarify that stacking these enhanced penalties in a single case is only permitted if there is a final prior conviction. However, Congress did not make that change retroactive. In Carter's case, for example, he received a 70-year sentence, 57 years of which were the result of the now prohibited stacking practice. If that law had been made retroactive, or if Carter was sentenced today, he would have faced just 21 years of mandatory time, which is a fraction of what he originally received. So these changes represent significant sentencing disparities. So after the passage of the First Step Act, the Sentencing Commission lost its quorum and could not update its sentencing reduction policy statement that Congress had directed it to do to reflect the Act's changes. So in this interim period, without the commission's guidance, district and appellate courts were interpreting the boundaries of extraordinary and compelling and what could constitute extraordinary and compelling reasons. And ultimately, a circuit split developed over whether the First Step Act's non-retroactive legal changes, like the mandatory minimum firearm changes, could constitute extraordinary and compelling reasons. So once the Sentencing Commission regained a quorum several years later, it acted to resolve this split. It held hearings, received extensive public comment, and ultimately promulgated what it called the unusually long sentence provision. And what this provision does is it allows courts to consider non-retroactive legal changes as one factor in a multi-factor analysis in deciding whether a person has presented extraordinary and compelling reasons. Other factors in this unusually long sentence provision include whether the individual has served 10 years or more in prison, whether there is a gross disparity between the sentence being served and the sentence today, whether the sentence is unusually long, and whether the prisoner's individualized circumstances warrant relief. Did this solve the circuit split? It did not. The Department of Justice objected to the unusually long sentence provision as legally invalid. So what happened was the pre-amendment circuit split simply replicated itself, leading to significant and troubling geographic disparities around the country over which prisoners were eligible for a sentence reduction under the provision. And this has meant that in the most extreme cases, whether a prisoner can receive a significant sentence reduction or is forced to spend the rest of their life in prison depends entirely on the circuit in which their case was charged. This is precisely the sort of unwarranted geographic disparity that the Sentencing Commission was created to prevent. The government ultimately agreed that cert should be granted to resolve this circuit split. So I want to talk a little bit about both sides' arguments. The government's position is that the unusually long sentence provision, by permitting courts to consider non-retroactive legal changes, is in direct conflict with Congress's determination that such changes only apply prospectively under the First Step Act, and that in any event, legal changes are ordinary, they are the regular business of the legal system, and they cannot be extraordinary. The government also argues that the unusually long sentence provision raises significant separation of powers concerns by allowing, in their view, the courts and the commission to circumvent Congress's express determination to make the First Step Act's landmark legal changes forward-looking only. And in making these arguments, the government asked the court to read an implied exception into the statute in which Congress clearly gave the commission express authority to set the parameters of what is extraordinary and compelling, with the only explicit limitation that rehabilitation on its own cannot be such a reason. Petitioners, on the other hand, emphasize that Congress's retroactivity decision is a system-wide determination, which cannot and should not bar consideration of non-retroactive changes in individual cases as part of a multi-factor analysis, like the unusually long sentence provision, which has several other considerations and prongs for judges to consider. They also argue that the term extraordinary and compelling is flexible and certainly broad enough to encompass the commission's approach, where a legal change is just one among many factors. Petitioners further contend that the government's position would impose a categorical bar on the scope of extraordinary and compelling reasons and would limit the commission's authority in a way that actually rewrites both the statute and Congress's directive, contrary to the statutory text. Additionally, these cases raise some interesting administrative law questions, in particular, how the court should treat express delegations like this one, which are not covered by the recent Loper-Bright decision. So, in other words, should expert bodies like the Sentencing Commission, which is charged with ensuring uniformity in sentencing and was expressly directed to set policy in this area, continue to receive deference when their decisions are reasonable? Several of my clinic's clients and other federal prisoners serving life and de facto life sentences that would be significantly lower today are anxiously awaiting the decision in Rutherford and Carter. And this is one of those cases where a decision in favor of the government would have very real and devastating consequences for these individuals. So that is Rutherford and Carter. I'm now going to turn to the Fernandez case, which I believe is going to be the last case argued in the November term. Fernandez, like Rutherford and Carter, is about the scope of the federal sentence reduction statute. So there are a lot of synergies between these cases. And I think it's pretty striking to see the court take up more than one case on this issue in a single term, let alone two. So in the interest of disclosure, again, I was part of a team that filed an amicus brief in this case on behalf of Mr. Fernandez. So these issues are very much a part of my practice in life and have been for several years. I am going to try to lay out both sides on this issue as well. The question presented in Fernandez is whether a combination of extraordinary and compelling reasons that may warrant this discretionary sentence reduction under the sentence reduction statute can include reasons that may also be alleged as grounds for vacatur of a sentence under 28 USC 2255, which is the federal habeas statute. In the proceedings below, the district court determined that Fernandez had presented extraordinary and compelling reasons based on a constellation of different factors. So these factors included serious concerns about the sufficiency and reliability of the evidence upon which Fernandez was convicted, questions about the effectiveness of Fernandez's counsel at trial, and significant disparities between the length of Fernandez's sentence and the length of his co-defendant sentences. Notably, the trial court judge went so far as to say that he felt disquiet about the case and conviction and came to doubt that the jury's verdict was correct. Needless to say, these are rare statements coming from a district court judge, and one might even say they are extraordinary and compelling. I had to get that in. Based on its finding of individualized, extraordinary, and compelling reasons, and that the other relevant statutory factors had been met, the district court reduced Fernandez's sentence to time served. However, that was not the end of it. The Second Circuit reversed the district court's grant of a sentence reduction, concluding that reasons related to Fernandez's innocence, which were embedded in several of the factors that the judge considered, were properly considered as grounds for vacatur of the conviction under the federal habeas statute, and therefore could not be considered by the district court in assessing whether extraordinary and compelling reasons existed. In reaching this conclusion, the Second Circuit read a categorical limitation into the sentence reduction statute that does not exist in this text, reasoning that allowing such consideration would create a conflict between the habeas and sentence reduction statutes. So in terms of what the parties are arguing, here, the petitioner's position, like the position in Carter and Rutherford, is a straightforward textual argument. The sentence reduction statute contains no categorical prohibition against finding extraordinary and compelling reasons related to a sentence or conviction. Again, Congress set this one explicit limitation, which was rehabilitation alone, demonstrating that Congress is clearly capable of setting limitations or carving out categorical bars of what can and can't be extraordinary and compelling when it wants to. Petitioner also argues that the two statutes are not in tension, because ultimately they provide different forms of relief, they employ different standards, and they can address different kinds of claims. The sentence reduction statute, on the one hand, addresses whether extraordinary and compelling circumstances justify sentence reduction. In this context, judges are not asked to rule and are not ruling on the legality of the conviction or sentence itself. Fernandez himself acknowledges that his sentence was lawfully imposed, but contends that the circumstances surrounding its imposition make it unjust. Petitioners further argue that, consistent with the broad discretion historically afforded to sentencing judges and a plain reading of the statute, judges should be able to consider any factors not expressly barred by the Sentencing Commission, Congress, or the Constitution. The government's position in Fernandez, especially when viewed alongside its arguments in Rutherford and Carter, is that the scope of the sentence reduction statute is exceedingly narrow, despite the statutory text, and contains numerous implied categorical limitations that cannot be found in the statute. The government asserts that Section 2255 is the sole avenue for any claim of error involving the sentence or conviction, even if that claim is not the sole basis for seeking a sentence reduction, as happened in Fernandez, and that the sentence reduction statute cannot operate in parallel to habeas or in any way subsume it. The government also points to the practice of how sentence reductions went when the Bureau of Prisons had the sole power to initiate motions, that sentence reductions during that time were principally about personal circumstances that could not be foreseen at the time of sentencing, such as medical and family circumstances, rather than the types of claims raised by Fernandez. These arguments should be very interesting, particularly for federal sentencing junkies like myself. In particular, I'm going to be watching for Justice Gorsuch and Justice Barrett's questions about statutory construction and how they approach the government's arguments for the numerous implied limitations in both cases. So those are my summaries of the federal sentence reduction cases on tap, and happy to answer any questions. Thank you very much.
Thank you, Professor Zunkel, and thank you again to all of our panelists for all of those great summaries of the cases. I'm going to briefly touch on 3 others that are to be heard in November. And like all of our panelists, I have to give a disclaimer, though it's a disclaimer of a different kind. Unlike all the panelists, I don't have any relation to these cases at all. I have not worked on any amicus briefs related to these cases, and many of them are somewhat outside of my area of expertise and practice, but it has been fun to learn about them over the last couple of days, and I'll give you some information about them. So the first is Hensley versus Fluor Corporation, which is to be heard on November 4th. This one deals with a personal injury suit against Fluor Corporation for injuries U.S. Army Specialist Winston Hensley sustained during a suicide bombing at a base in Afghanistan that was carried out by an Afghan employee of Fluor Corporation, which is a government contractor that worked on the base. Hensley sued Fluor in the U.S. District Court for the District of South Carolina, alleging various negligence theories under South Carolina law for those injuries that was carried out by the employee of Fluor Corporation. Sovereign immunity generally prohibits suits against the sovereign for damages, but the government, as I'm sure you all know, can waive sovereign immunity and has done so in several contexts, including the Federal Tort Claims Act, which waives sovereign immunity for harm caused by the negligent or wrongful conduct of government employees to the extent that a private person would be liable under the law of the place where the conduct occurred. The law includes what is called a combatant activities exception, which provides that there's not a waiver of sovereign immunity against any claim arising out of the combatant activities of the military or naval forces or the Coast Guard during time of war. So understandably, the government might not want to waive, and therefore did not waive, sovereign immunity from suit for negligence in situations like combat, which are inherently dangerous, involve all kinds of chaos, risk, injury, and death. Under the terms of the Federal Tort Claims Act, though, the combatant activities exception does not apply to government contractors. However, in a case called Boyle versus United Technologies Corporation in 1988, the Supreme Court held that sovereign immunity also protected a military contractor from a suit alleging that its design of a military helicopter was defective and dangerous. The Boyle court reasoned that it would interfere with a uniquely federal interest to permit a government contractor to be liable for conduct required by its contract with the United States. So the lower court in Hensley held that federal law did in fact preempt Hensley's state law claims against Fluor Corporation. So quoting Boyle, the Fourth Circuit said, in areas involving uniquely federal interests, a Federal Tort Claims Act exception can demonstrate the potential for and suggest the outlines of significant conflict between federal interests and state law, sufficient to warrant federal preemption, even absent a statutory directive or direct conflict. So you have a situation where the statute appears to exempt government contractors from the exception to the waiver of sovereign immunity. But even though the statute says that, the courts have read it because of the unique interests allegedly involved to still preempt those claims. So to the Fourth Circuit, when the government contractor is sufficiently integrated into the overall combatant activities, then the federal interest underlying the combatant activities exception extends to those contractors, since imposing liability on them could essentially interfere with the decision-making of the military entities that contract with those contractors. So the question for Hensley is whether the reasoning of Boyle, which dealt with situations where the contractor was doing what the contract actually required, extends to a situation where the government contractor allegedly breached its contractual obligations and violated military orders, since that's what Hensley said Fluor Corporation did when it negligently supervised the Afghan employee and other problems with the way that it administered the responsibilities it had on the base. So that is Hensley. The next case that I'm going to briefly cover is Coney Island Auto Parts Unlimited versus Burton, which is also going to be heard on November 5th. This case deals with whether or not a motion to vacate or set aside a judgment that was void allegedly from the start has to be filed within a reasonable time. So Rule 60B provides grounds for relief from a final judgment. Rule 60B-4 specifically permits relief where the party can show that the judgment was void. Rule 60C says that a motion that is brought under Rule 60B must be made within a reasonable time. So the rule requires a specific time, which is 1 year, for certain grounds for relief under Rule 60B, but it does not give a specific time frame for a motion filed for relief from judgment on grounds that the judgment is void. The question in Coney Island is whether this rule imposes a time limit on a motion when the original judgment was void for lack of personal jurisdiction. So the facts in that case involve Coney Island Auto Parts being sued for money that it allegedly owed to Vista Pro Automotive in Tennessee. Coney Island Auto never responded to that complaint. So there was a default judgment issued against it in Tennessee in 2015. 5 years later, the trustee in Vista Pro's bankruptcy proceedings registered that Tennessee judgment in New York and served a subpoena and a restraining notice on Coney Island's bank, which then placed a hold on Coney Island's account. Coney Island moved in New York for the bankruptcy court to vacate the Tennessee judgment on the grounds that it had not been properly served, and therefore there was never any personal jurisdiction in the first place. They're saying that the judgment was void all along. The court in New York agreed with Coney Island's claim about personal jurisdiction, but it declined to vacate the judgment for reasons of comedy, and on appeal to the Southern District of New York, that court agreed and instructed Coney Island to try to get the judgment vacated in Tennessee, which it did. So going back to Tennessee in September 2022, 7 years after the original default judgment was entered, the court in Tennessee denied the motion to vacate, relying on the Sixth Circuit's interpretation of Rule 60C1's requirement to file in a reasonable time. So the Sixth Circuit stands alone on this issue and says that even when you're saying the original judgment was void from the start, there was no personal jurisdiction, there's still a time limit on being able to get relief under the federal rules of civil procedure. So every other circuit has held that there's no requirement for that kind of a motion in that particular circumstance to file within a particular time. And so the question for the Supreme Court is whether the terms of Rule 60 do apply, even if you're saying there was never personal jurisdiction for the judgment. And finally, To be heard on November 10th is a case called the Geo Group versus Medi-Cal. Here's another case involving government contractors and sovereign immunity, but this one deals with whether a contractor claiming that sovereign immunity bars the underlying claims, whether when you claim that sovereign immunity bars your underlying claims, the question is, can you immediately appeal if the trial court denies sovereign immunity? So generally speaking, the courts of appeals have jurisdiction over final decisions of the district courts of the United States. But the Supreme Court has recognized that the term final decisions is not just the same thing as final judgments, but also includes what it describes as a narrow class of decisions that do not terminate the litigation, but are sufficiently important and collateral to the merits that they should nonetheless be treated as final. This is called the collateral order doctrine. If a district court enters an order that falls within that category, it can still be immediately appealed. But understandably, the courts police this doctrine narrowly as they can. And so an order to be appealable under this doctrine has to meet three requirements. The first is that it conclusively determines the disputed question, whatever that is. Second is that it resolves an important but completely separate from the merits of the action, an important issue, but it's completely separate from the merits of the action in the case. And third, it would be effectively unreviewable on appeal from a final judgment. And a good example of that is immunity. If you claim that you have immunity from suit, then if you have to still go through a trial, that is effectively unreviewable on appeal from a final judgment because you lost what the immunity was supposed to give you in the first place. Geo Group concerns claims brought by ICE detainees against Geo Group, which operates a private immigration detention facility. The detainees claim they were forced to do labor in violation of the Federal Trafficking Victims Protection Act and raise several other state law claims. Geo Group claims that it has derivative sovereign immunity as a government contractor. The Supreme Court has recognized such immunity, but it can only be claimed if, one, the government legally conferred its authority to the contractor, and two, the contractor was acting in compliance with the government's instructions. The 10th Circuit held that when the district court denied Geo Group's claim to derivative sovereign immunity, that order was not immediately appealable under the collateral order doctrine because it could not be reviewed separate from the merits. That's the second collateral order factor. In order to determine whether the contractor has sovereign immunity, the court would have to determine whether the contractor was actually acting in compliance with the government's instructions, which in turn would require the court to evaluate the lawfulness of the conduct itself. And so the 10th Circuit said, we can't figure that out, essentially, without looking at the merits. And because we can't figure that out without looking at the merits, this is not a collateral order that can be immediately appealable. So the outcome is that government contractors who might have a legitimate claim to immunity can still be forced to go to trial with the option of appealing the denial of immunity later on. But as we noted, that's sort of futile, since part of what you're supposed to get from immunity is immunity from suit in first place, not just a defense to liability. So the question for the Supreme Court is whether that's correct. It seems like the right application, perhaps, of the elements of the collateral order doctrine, but it's also in tension with the nature of immunity defenses, sovereign immunity in particular, which is not just a defense to liability, it is a defense from suit, immunity from suit. So those are our cases. I'm going to turn now to a few minutes of questions. I appreciate those of you that have submitted them. And I want to prioritize what the audience has asked about. So as I mentioned, Zach, we're going to get back to the Trump tariff case. And one question here is, are all of the tariffs that President Trump has been issuing sort of around the world that you described, are all of these being imposed under the statutory authority, the IEEPA claim that they're making in this case, or has the president been relying on a range of different statutory grants of power for some of the different tariffs?
The bulk of the tariffs is when the president was sworn in, the general tariff rate was something like 2%. Now it's about 18%. That's mostly IEEPA. It's not exclusively IEEPA. So for instance, the tariffs that the president imposed in response to protect the American furniture industry, he imposed those under a national security tariffing authority that requires an investigation and then a report being given to the president, and then the president can take action. One of the real distinctions, by the way, and one of the arguments for why IEEPA really isn't likely to be a tariffing authority is there are a host of statutes in Title 19, which is helpfully called customs duties, that give the president the authority to change tariff rates, but he has to do so usually after a notice and comment period or after a mandatory investigation, something along that nature. Whereas in Title 50, which is War and National Defense, which is where IEPA is, he claims a right to have sort of an unbridled whipsaw authority over tariffs entirely, and that he can raise and reduce rates at will, so long as he unlocks the IEPA powers through a national emergency declaration. So not all of the tariffs, to answer the question, are unconstitutional. Some of them have been done through the normal process that provides some certainty to the business community, but the vast majority of the president's tariffs have been done through the IEPA process.
Very helpful, thank you. And one other question that I think is pretty interesting, which is, I think everybody saw the sort of spat between the president and Canada over the commercial quoting President Reagan and what he said about tariffs. Do you think that that's likely to come up? Is that something the court might consider when sort of evaluating the statutory authority here?
I think so, just because it demonstrates the sort of caprice problem that. Yeah. So again, Justice Barrett, I think, has the best articulation of the major questions canon, right? Her sort of the ambitious babysitter analogy that if you leave $50 on the nightstand table for the babysitter, give the babysitter the instruction to let the kids have fun, you take the money, you steal a credit card, you take the kids on a week-long trip to Six Flags. That's not really, that is letting the kids have fun, but it's not a faithful execution of the orders of the parents, the babysitter. Part of reading text in context is it really likely that not just that Congress would have given the president a tariffing authority, but one that is so suspect to just the whims of one man? Does he have that whipsaw authority over regulating the entire $7 trillion American import-export market? So I think what it is it's a very, very nice example of how extreme the president's claim is under IEPA. And so, yeah, I would expect there's going to be some questioning about it.
And one other question that our audience wanted to know on this. Were there any amicus briefs that treated any arguments or made any important points that the parties haven't directly addressed? I think they're just looking for additional reading on the case.
I mean, there's a lot of amicus briefs. Strongly recommend the Washington Legal Foundation's brief, which is brilliant and incredibly persuasive. You read that, you know the case, you're done. I'll point out one brief that I particularly found useful. The National Taxpayers Union Foundation filed an amicus brief in response to not really talking about the legal merits so much, but the president's brief has a lot of apocalyptic rhetoric about what the economic consequences would be if his tariffs were struck down. You read the brief, it's like reading a Justice Jackson dissent. It's just incredibly apocalyptic rhetoric. And the National Taxpayers Union Foundation's brief really takes the president's points bit by bit and responds to them. I would recommend reading the president's brief, particularly the introduction where they talk about the economic consequences. Read Entough's brief after that. It's a very good A and B conversation about what the consequences would actually be if the court strikes down the tariffs.
Great, thanks very much. We got a few questions about our RLUIPA case. Professor Berg, one thing that just came to my mind as I was listening to your description of that case is, was there any kind of Section 1983 claim at any point in the litigation brought against the officers in their individual capacities?
Not that I know of. Not that I know of.
That's interesting because obviously, as you sort of described, you've got RFRA and RLUIPA being enacted sort of follow Smith to try to sort of deal with the problems of general applicability and neutrality that case imposed. But this seemed like a case where as a matter of the First Amendment, and you've got sort of what seemed like in the facts pretty naked hostility and retaliation, you wouldn't have any kind of general applicability neutrality problem there. So it's interesting.
Yeah, so it started out as a pro se case, and I don't know what the folks at Weil Gotshal added. You would have, I guess, an issue about neutrality and general applicability under the free exercise clause if you invoke Section 1983. This could be a one-time thing, although that prison may have had a rule against hair length, etc., which would, if it were a general rule, it would have to be attacked under ARLUPA rather than the free exercise clause, although the hostility manifested in the encounter would give a decent free exercise claim as well.
Yeah. One question our audience wanted to know about ARLUPA is, what are sort of the limits on what institutionalized persons can raise, or what kind of requirements are they able to get out of? I think the audience member would be helped probably just by a description of how, the legal standard that ARLUPA brings back after Smith.
Yeah, so Congress adopted the same standard, which is a strong standard, compelling interest achieved by the least restrictive means. But Congress said, and the court has also said in interpreting ARLUPA, that you read that in the context of prisons, where there are particular interests in order and security, and where prison officials have some expertise, experience that's better than courts' experience and expertise in managing prisons. So it's it's always an interesting. I ask my students, what does strict scrutiny with some deference mean? Right, and that's what it is. It works out on the facts of the case. If there were some indication that there's a possibility of hiding contraband in dreadlocks, then landlord would not have a case under ARLUPA. The one Supreme Court case on this involved a short beard by a Muslim, worn by a Muslim prisoner, and the court said, well, we don't see any indication that a 1/4 or a 1.5 inch beard could be used to hide contraband, but a longer, the implication is that a longer beard might. So, maybe that comes out to something closer to intermediate scrutiny, but the prison officials have to articulate their case strongly in order to satisfy strict scrutiny, even with that degree of deference.
Thank you very much, Professor Berg. The question for Professor Zunkel about Fernandez. I was wondering, did Fernandez try to get vacatur of his conviction under Section 2255 at any stage of that case?
I believe that he did. I am not. I think that this case had a long procedural history, but I believe he did, and that was not successful.
And does that play into, so the question here is, I think, whether you can use whatever was raised as those factors to then consider the extraordinary compelling reasons under this to get a sentence reduction. So if a court had considered but rejected that claim, how would that look? Was it saying basically your showing wasn't strong enough for getting your sentence vacated, but it could still play into extraordinary circumstances, or what's the right approach?
Yeah, what Mr. Fernandez argued at the district court level is that there was some overlap, I think, in what could have been alleged in the habeas context, but it was really going to the validity of the conviction and sentence, where here it was acknowledging the conviction and sentence were lawfully imposed. Like, that's the question in habeas, is that lawful? And the question at the level of the district court deciding whether the constellation or combination of circumstances was extraordinary and compelling was, does this combination of circumstances, some of which may be alleged in a different, through a different remedial vehicle, also be considered in this separate proceeding? And there were other factors that the judge considered as well that wouldn't have necessarily been a habeas issue. So I think it's isolating the habeas factors, or factors that could be alleged in habeas, versus ones that in a combination of circumstances could be presented in this separate forum.
That makes sense. Thanks very much for that. And we promised you all 90 minutes or less, so I want to stick to that to be respectful of everyone's time. Thank you all again to our panelists for contributing. This was an excellent discussion. So this has been a seat at the sitting, and we are adjourned.